I will be handing down the judgment in the appeal of Halliburton and Chubb. In 2010, there was an explosion and fire on the Deepwater Horizon drilling rig in the Gulf of Mexico. Lives were lost, and there was extensive oil pollution and property damage. Legal claims were made against BP, which was the lessee of the rig, Transocean, which owned the rig and provided crew and drilling teams, and Halliburton, which provided cementing and well monitoring services. Halliburton and Transocean were each insured by Chubb under a Bermuda form liability policy. Both Halliburton and Transocean settled the legal claims made against them in the United States and sought to recover their payments in settlement under their liability policies from Chubb. In each case, Chubb refused to pay out, contending that the settlements which had been reached were not reasonable. The Bermuda form policies provided that disputes were to be resolved by arbitration before a tribunal of 3 arbitrators. Each party to an arbitration was to appoint 1 arbitrator, and the third was to be appointed by agreement, which failing by the High Court in London. Halliburton and Chubb each appointed an arbitrator, but as they were unable to agree on who should be the third arbitrator and chairman of the tribunal, he was appointed by the High Court. His appointment had been proposed by Chubb, but opposed by Halliburton. Subsequently, this arbitrator took on further appointments as an arbitrator in 2 other arbitrations concerning the Deepwater Horizon incident. In the first, Transocean appointed him to hear its claim against Chubb, and in the other, he was the joint nominee of the parties in relation to a claim by Transocean against another insurer. The arbitrator did not disclose these later appointments in the related arbitrations to Halliburton. When Halliburton learned of them, it challenged the arbitrator to explain himself and then applied to the High Court under Section 24 of the Arbitration Act 1996 for the court to remove him as arbitrator. The ground of removal on which Halliburton relied was that there was a real possibility that he was not impartial. The High Court and the Court of Appeal refused the application, and Halliburton now appeals to this court. The principal legal questions raised in the appeal are 2 in number. The first is whether an arbitrator's acceptance of multiple appointments involving a common party, in this case Chubb, and the same or overlapping subject matter, in this case liability insurance claims arising out of the Deepwater Horizon disaster, could give rise to the appearance of bias. The second question is whether and to what extent an arbitrator can accept such appointments without disclosing them. The matter is of considerable importance in the world of arbitration, and the court has been assisted by interventions from various bodies which have expertise in this field. The court is very grateful for their assistance. The court unanimously dismisses the appeal. I give the leading judgment with the agreement of Lord Reed, Lady Black, and Lord Lloyd-Jones. Lady Arden gives a concurring judgment, reinforcing and qualifying the conclusions reached in the majority judgment and analysing the duty of disclosure and its relationship to the arbitrator's obligation of confidentiality. The court holds that the duty of impartiality is a core principle of arbitration law, which applies equally to party-appointed arbitrators and independently appointed arbitrators, where, as in this case, the court is dealing with an allegation of apparent bias and not an allegation of actual bias. The court applies an objective test, asking itself whether a fair-minded and informed observer would conclude that there was a real possibility of bias. In applying that test, the court must have regard to the particular circumstances of international commercial arbitration, which the court describes, and which differ from those of litigation in public courts. The court holds that an arbitrator is under a legal duty to disclose matters which might reasonably give rise to justifiable doubts as to his or her impartiality. That duty does not override the arbitrator's duty of privacy and confidentiality in English law in relation to the other arbitrations, and where the information to be disclosed is covered by the duty of confidentiality, the arbitrator must obtain the consent of the relevant party or parties for that disclosure. In assessing whether an arbitrator has failed in his duty of disclosure, regard is to be had to the facts and circumstances as at and from the time the duty arose. By contrast, and this is important to the outcome of this appeal, when assessing whether there was a real possibility that the arbitrator was biased, the court will have regard to the facts and circumstances known at the time of the court hearing to remove the arbitrator. In answer to the first question, and differing from the Court of Appeal, this court holds that there may be circumstances in which an arbitrator's acceptance of multiple appointments involving a common party and the same or overlapping subject matter would, without more, give rise to an appearance of bias. Whether the acceptance of such an appointment does so will depend on the customs and practices in the relevant field of arbitration, as some fields of arbitration involve related appointments without the parties having any concerns about bias. In answer to the second question, the court holds that where, as in the Bermuda form arbitration, the circumstances are such that the acceptance of multiple appointments might reasonably give rise to the conclusion that there was a real possibility of bias, the arbitrator is under a legal duty of disclosure. That duty arises out of the arbitrator's statutory duty to act fairly and impartially, and gives rise to an implied term in the arbitrator's contract. A failure to make such disclosure is itself a relevant consideration when the court decides whether there is apparent bias. Applying this analysis to the facts of the case, the court holds that the arbitrator was under a legal duty to disclose to Halliburton his appointment in the subsequent reference involving Chubb and Transocean, and that he failed to do so. But by the time the application to remove the arbitrator was heard at first instance, the fair-minded and informed observer would not infer from that failure to disclose that there was a real possibility of bias. The failure to disclose was an oversight at a time when it was not clear whether English law imposed a legal duty of disclosure. Secondly, the Transocean arbitrations commenced several months after the Halliburton arbitration, which would normally be expected to be heard first. Thirdly, the arbitrator explained that the subsequent references were likely to be determined by a preliminary legal issue, so that Chubb would gain no advantage by being a common party to related arbitrations. The arbitrator offered to consider resigning from the Transocean arbitrations if they were not resolved in that way. Fourthly, there was no question of the arbitrator having received any secret financial benefit. And finally, contrary to Halliburton's submission, there was no basis for inferring from the arbitrator's actions that he bore any unconscious ill will. Halliburton's challenge therefore fails.